Welcome to EUPrivacyForAll Session54 on GDPR, Obligations of Secrecy, Article 84. In the frame of negotiations regarding Article 84, nothing special should be noticed, apart from the fact that European Parliament suggested that this would be an obligation for member states to ensure that specific rules are in place, shall has not been retained in the final draft, and on EU Council side, reference to a code of professional ethics was neither retained. Article 84 lays down that member states may adopt specific rules to set out the powers of the supervisory authorities in relation to controllers or processors, subjects under EU or national law, or rules established by a national competent body, to an obligation of professional secrecy, where this is necessary and proportionate to reconcile the right of the protection of personal data with the obligation of secrecy. In a second paragraph, it is laid down that each member state shall notify the Commission at least 2 years after the 20th day following publication of the GDPR about those rules. Recital 127 mainly recalls what is already provided in Article 83. Other recitals provide additional insight, indicating possible criminal acts or threats to the public security by the controller to a competent authority shall normally be regarded as being in the legitimate interest of the controller. However, such transmission should be prohibited if the processing is not compatible with legal, professional, or other binding obligation of secrecy. Additionally, the regulation should provide for harmonized conditions for the processing of special categories of personal data concerning health, in particular with regards to professional secrecy. Article 9.2 HB stresses the fact that the processing of special categories of data shall not be prohibited if the processing is necessary for reasons of public interest in the area of public health on the basis of EU or national law, which provides for suitable and specific measures to safeguard the rights and freedoms of the data subject, in particular with regard to professional secrecy. In the frame of the provision of health or social care or medical treatment, it is made really clear that personal data may be processed for those purposes when they are processed by or under the responsibility of a professional subject to the obligation of professional secrecy. It is also recalled that the obligation of information of data subjects shall not apply where the data must remain confidential, subject to an obligation of professional secrecy. Finally, the provisions of Article 36.4 and 49.2 make clear that both data protection officers and the members and staff of the supervisory authorities are bound by an obligation of secrecy. Currently, the directive lays down in Article 8.3 that the prohibition of the processing of special categories of data shall not apply where the processing is necessary for purposes of preventive medicine, medical diagnosis, provision of care, or treatment of the management of healthcare services, processed by a health professional subject to the obligation of professional secrecy. In Article 28, it is laid down that members and staff of the DPA are to be subject to a duty of professional secrecy. What should accountable data controllers and processors get prepared for? First, they should pay attention to the fact that specific national rules may be adopted by member states to set out the investigative powers by the DPAs in relation to controllers or processors bounded by an obligation of professional secrecy. Second, Such law will frame situations in which it is necessary and proportionate to reconcile the right of the protection of personal data with the obligation of secrecy. The Commission will be notified such national rules. Controllers only should know that indicating possible criminal acts or threats to public security to a competent authority is prohibited if the processing is not compatible with a legal, professional, or other binding obligation of secrecy. There is no obligation of information of data subjects where the data must remain confidential. Overall, medical diagnosis and the provision of health or social care or treatment shall be processed under the responsibility of a professional subject to the obligation of professional secrecy. Finally, DPOs and DPA staff are submitted to an obligation of secrecy under the GDPR. So the question raising now is knowing how an harmonized approach on secrecy could be provided in EU regarding the processing of health data.